Okay, here is a Michael Popok video on the issue of Section 3 of the 14th Amendment, again, citing off the Hill article. He doesn't ever put it up, and my God, he gets so much stuff wrong and confused in here. It's another embarrassing. Popok and Meidas are just two failed lawyers. They just deserve no respect, really. There's the title, and there's the date that it was posted. So this is going to jump to where he makes his first mistake. There's the URL at the top.
By a close vote at the Colorado Supreme Court, and there they ruled that he was an insurrectionist and should be banned from the Colorado ballot, which brought us to the end.
Okay, he's trying to give a summary of something that doesn't matter. You know, he spent already, 3 minutes and 30 seconds. You go back and watch the whole thing. The URL was at the top before. You can stop at the ampersand T equals. Anything beyond that doesn't matter. But Colorado does not matter. It's a dead issue. Okay, again, over and over and over and over and over again, insurrection is a dead issue. Stop it. Stop it. Stop it. Forget it. Rebellion is the route. No one is saying it. But listen to this.
Anderson decision. So the mechanics are there. So I started the hot take with, should 20% of the Democrats in the House and the Senate object to the Electoral College vote, at least as a moral objection, even though it may...
No such thing as a moral objection. Either it's an objection under law, or it's not. Now you sound like a Republican, making up BS. He's not looking at what Section 3 of the 14th Amendment requires. It doesn't require 1/5 from each house. There's a problem with that. It's unconstitutional. The Constitution does not say you can make legislation that bars Section 3 of the 14th Amendment from being enforced if 1/5 of each house, its members, don't agree, to object. And then what's the objection based on? He doesn't say.
May not, and is, let's be frank, won't lead to enough of the majority of the House and the Senate to confirm that or affirm that to take Donald Trump.
Majority. There's no majority. It's 2/3 majority to vote to remove the disability. The objection would be he's already disabled. So he's understanding this completely backwards. The Supreme Court has already said this. It activates on your conduct. The constitutional ineligibility is already in place. And I get the feeling that Trump knows he may be in for a rough go on January 6th. So he's been silent. Wrong number one.
Trump's electoral votes away from him and declare Kamala Harris to be the president. Is there a moral value?
There is no away from him. They are set aside. They're set aside, period. And then the votes are reduced by the number of those votes that are set aside. He doesn't own the votes. He's constitutionally ineligible. He'll own the votes if and only if Congress votes to remove the disability. See, this guy has got it completely backwards. And this is why when you get old and you're stupid, you especially shouldn't get on TV and talk about the law.
Value to doing that? Yeah, I'm not going to debate that. Sure. If I was in the House, I may lead the charge and get up there and say and try to get 20% of my votes, which is like 42, 43 other voters to come along and declare that, and shave off a lot of the votes for Donald Trump and try to declare Kamala Harris the winner. But then you need...
This is where he's wrong. You're not shaving off anything. It doesn't work the way he's thinking, the old way it used to work. There is no vote to certify. There's a call for objections. No valid objections being found. The votes are counted. That's it. There is no shaving off the certification. If you don't object, there is no other way to stop it.
For that to happen, even if you get over, was he properly declared to be an insurrectionist? And if you get over the fundamental question coming out of the Anderson decision, which is...
See, here we go. Here we go. There was never a question. There is no question whether he was declared to be an insurrectionist. That doesn't matter. What matters is his conduct. The Supreme Court has said it. It activates on his conduct. The bar to office activates on his conduct. He is constitutionally ineligible right now. Popok has got this so backwards, inside out, upside down, and stupid. If I were him, I'd take this video down. Too late. I got a full copy of it. This is stupid extraordinaire.
Is Section 3, Article 14...
Here he goes.
Sorry, the 14th Amendment, Section 3, is that self-effectuating, activating, or does it need a new law of Congress to be established, a new...
Who are you asking? What the fuck are you doing? Who are you asking? If you don't have the answer, don't come on here asking the ether, is it self-executing? Because if people tell you, even when they tell you in the comments, you guys delete it. You delete it, you don't listen. You don't want to hear it. You're wrong. The Supreme Court is telling you it's self-executing. It activates on conduct and nothing more. Meaning there is no charge, no court, no indictment, no jury, no nothing. The conduct alone activates the bar to office. That's the clearest thing the Supreme Court said, but you know what? You can't read it. It's too clear. This is the ding-dong here.
Process of Congress to be established, not for disability removal, as some people have argued, but to actually implement Section 3. Because whether you call it dicta or you call it the...
And here we go. He doesn't understand what the order is saying. The order is speaking to legislation possibly needed for a state to do this, to adjudicate an insurrectionist on a federal level. Well, the previous videos that we put up, show exactly that there is already legislation in place. And you bring the case in the D.C. District Federal Court. That's who has jurisdiction. Congress has granted them jurisdiction years ago. But of course, Mr. Roberts don't want you to know that. This guy's nuts.
Holding of the decision in the summer, and I know that difference matters. There's a debate which has not been resolved by the United States Supreme Court as to whether there needs to be another action taken by Congress in order to declare someone an insurrectionist. There is no debate that...
He's stuck on insurrectionist. First of all, nobody gives a damn about insurrectionist because that's been clear for years. You have to go to court to get the title of insurrectionist adjudicated upon you. You do not have to go to court. to be in rebellion, to be found in rebellion to any part of the Constitution or congressional laws. That's the issue here. This guy is so screwed up in the head. I'm going to just zip. You know, I would be stopping every other word, because he's got it. Everything out of his mouth is completely wrong. What's next?
The Constitution and the ruling in Colorado says that in order to remove a disability from somebody, the insurrectionist label has to be done through an act of Congress. But the question is under Section 3 and Section 5 of the 14th Amendment, whether Congress needs to take another step and pass another law or mechanism in order for that to happen.
He's so confused. Okay, first of all, is with regard to the state. With regard to a state, if you're going to let a state determine an insurrectionist in their courts, yes, you're going to need legislation to let states do that. And then, yes, Section 5 will be required to create the legislation. There is nothing to create legislation upon Section 3. It is clean, it is clear, it is self-executing. Supreme Court said that, which he keeps saying back in the summer. What the hell is he talking about? It was March 4th, 2024. That's not the summer. This is Popok. He just gets everything wrong. What next?
Or is it just self-actuating? I have all these people, I've heard all these people on YouTube say, he's an insurrectionist. I can see with my own eyes. I can read. I heard somebody say, I can read.
What people say has no merit to especially an attorney. If you're saying something without backing it up with law or a legal theory, it's just nothing. It's nothingness. He's not an insurrectionist because an insurrection did not occur. He attempted to incite an insurrection, but he never was charged with that criminally. Had he been charged with it criminally by Jack Smith, the bar to office would still, to this moment, be even firmer attached. It's already attached because the House of Representatives declared him an insurrectionist by charging him with incitement to insurrection. At that moment, the word alone, incitement to insurrection, summons 18 U.S.C. 2383 in our law, and the bar to office automatically attaches. If he could not get an acquittal of 2/3, the majority of the Senate, then his bar to office becomes a disqualification, which is where he is right now. Except that's Congress. And where they screwed the pooch there is that Justice Roberts walked out. He would not preside over the Senate proceedings. So they didn't have a trial. They passed a resolution, because without the Supreme Court, you can't try the president or an ex-president. However, the bar to office attaches with or without the Chief Justice. He doesn't explain any of this. He doesn't know it.
I can read too. I can also read the Supreme Court decision, and I also see the cards in front of me about the Supreme Court. Did the majority of the Supreme Court say in their holding that under Section 3 and Section 5 of the 14th Amendment that Congress has to act before an insurrectionist is banned or barred from taking office? That is one legitimate...
Again, it's regard to a state. A state. Does Congress have to act to allow a state to declare a federal candidate an insurrectionist? And the answer is yes. It's always been that way. But you're so confused in your head. You don't know. You don't understand constitutional law. You don't understand what you're talking about. And we're only 6 minutes in to his 20-minute video. You're welcome to go listen to the rest of this. I'm going to zip past this because he's just nonsense. He's nonsense all the way through, asking questions into the ether of YouTube, and there's never going to be a response. There'll be comments, thousands of comments, all of them one-liners. Lock him up, put him in jail, put him in hell, quit him already, should have been in jail. None of that is legal. None of that is legal information. None of that is legal argument. And if someone does post legal argument and legal information, anything meaningful, they delete it. You betcha. They delete it. It'll disappear. You go and you log in and you look, and it looks like your comment is still there. But the way YouTube works is you're always going to think your comment is there, and they've deleted it. And it'll always show that you put up the comment. But if you go to another machine where you're not logged in and you look for your comment, it won't be there. So don't think for 1 minute that Meidas Touch is innocent in this. They are manipulating it to keep from looking like fools. Because they are. They're fools. Popok and Meidas. Just so wrong. So wrong. And this is the first time the opportunity exists to just show how wrong they are. What now?
Way to read it. There's no other way to talk about the language in the Anderson decision from the summer, in which the Supreme Court majority says Section 5 and Congress's role in implementation is a critical component of the 14th Amendment. I don't know how else you read that. You'd have to read it out of your analysis.
That's how you read it. The state. In regard to the state. That's how you read it. It is limited to state power. And since they didn't make that clear to you, you read it more broad than it's written. Because in the same order, and it's not from the summer, March 4th, 2024 is not the summer. I don't know what to say. It's a shame that he has such a big platform to be so wrong. He's not doing the country any favors. He might as well be a Republican operative.
In order to say, I can read the 14th Amendment, it should apply. Now, you also have to get over the hurdle about sort of the findings against Donald Trump. I think we can all agree it can't just be a poll. Like, let's take a poll to decide whether Donald Trump was an insurrectionist. I think we'd win that poll. Maybe 52, 58, 59.
Stop with the insurrectionist. That's where you just have to stop. I'm not going to keep listening to him talk about insurrectionist because that's a dead issue. Insurrection requires a judicial determination. Rebellion against the Constitution or criminal laws, congressional laws, normally criminal congressional laws, but congressional laws is also a violation of Section 3 of the 14th Amendment. And that is the route that you should have taken. I'm just gonna zip past all of this and go to the end.
Violated the Electoral Count Act because you've made a decision about the regularity of that vote given that's improper.
What the hell? See, this is where the phrase is not regularly given. Period. Okay? Meaning the person is constitutionally ineligible. So there is no vote to be regularly given. You can't give a vote to someone who's constitutionally ineligible. Stop trying to make it into some other phrase. Oh my God. What now?
Under the way we interpret insurrection and 14th Amendment.
Insurrection.
And so we're back to the 14th Amendment, Section 3.
Do you see how he's making no sense? A vote not regularly given has nothing to do with insurrection. Absolutely nothing to do with insurrection. Anything he says about insurrection is completely irrelevant. Now, after this, I'm going to show you an actual legal argument to the D.C. District Federal Court, and whether it will be acted on in time, nobody knows. Let's get closer to the end and one more jump to wherever it lands.
That independent analysis and commentary on independent channels is important right now, I believe. But that's not why I went to the blackboard to explain the 14th Amendment, Section 3, Section 5, all of the different cases, all of the different...
Okay. He thinks he's explaining something, and he's completely, absolutely, completely wrong. If he knows so much, then actually file something in the court. File in the court that has jurisdiction over Congress and make Congress do their job. You didn't do that. All you want to do is collect advertising dollars from Google. Get more people to watch your videos, like your videos, comment on them, so you make that advertising money from Google. Okay, since the 28th, 3 more YouTube creators have jumped on the same article from The Hill by the 2 ex-law clerks of Justice Potter Stewart. The most recent is Anthony Davis, the Brit who knows everything. Basically recites what it says. It doesn't give credit for where it came from, just recites it with authority. And he's wrong. He gets it wrong because he doesn't understand what he's reciting. Unfortunately, the article is wrong on one aspect, and it's a major aspect. Insurrection is a dead issue. The adjudicated insurrectionist thing, that whole case is a dead issue. I don't know why people can't get past that. A state cannot declare Trump an insurrectionist. Not in a federal sense. You can declare him an insurrectionist in a state sense. If Trump was to run for some state office in Colorado, he would be ineligible. This right here is an actual legal argument sent to the D.C. District Federal Court. It's tied up in holiday shenanigans. I don't know if it will get heard in time for a ruling for January 6th. There's also a moratorium on civil proceedings because appropriations haven't been passed. So the court has suspended all civil proceeding work from the district of Columbia Attorney's Office. Don't know where that would fall. But this right here is the argument. Before we go on a little further, I'd also mention that Michael Popok jumped in. And my God, he didn't get into it 4 minutes before he was just all discombobulated, completely wrong, saying everything wrong. He didn't understand anything. I will play some of his bloopers after this. They're just disgusting. I wouldn't want to repeat it. One thing he says is no federal court has issued a ruling on insurrection. Well, no, they haven't. And that's because the D.C. Circuit Court of Appeals issued a ruling on rebellion that Trump violated Article 2, Section 1, Clause 1, which is all you need. So, this is the Supreme Court ruling right here on March 4th, 2024, that, quote, Section 3, unlike other provisions of the 14th Amendment, prescribes conduct of individuals. It bars persons from holding office after taking a qualifying oath and then engaging in insurrection or rebellion. Nothing more. Okay, that's a way of saying nothing else is required. It attaches on your conduct. And that's the Supreme Court. That's right in the order. So, this is the so-called self-executing nature of the Section 3 to 14th Amendment. The argument is only one person need raise the Section 3 to 14th Amendment objection by the Constitution itself, showing the conduct and proof by any public record thereof to activate enforcement of the bar to office. In United States versus Donald Trump, the case before Judge Chutkan, the D.C. Circuit ruling in the immunity claim appeal cites Article 2, Section 1, Clause 1. And it gives a link to that ruling. It says where to find it and gives the exact quote here. And then it says, rebellion is defined at 18 U.S.C. 2383. Raskin has been claiming that the Supreme Court has allowed Trump to remain on the ballot, even though he's an adjudicated insurrectionist. That's not here nor there. And this is where everybody keeps making the same mistake. So here is the issue. In an article posted by Politico, it shows that the Democrats fear Trump and his supporters. There's no need to win against a constitutionally ineligible candidate to hold office. The Democrats have the source of an objection draft they can use. So, it's been sent to about 25 of them, 25 or 30 of them, by fax. And that's enough for them to, if they read it, to get the message. But members of Congress aren't all attorneys. More Democrats than Republicans, but they simply do not have the constitutional smarts to read what the Constitution says. Even the attorneys. even Mr. Raskin, because he doesn't know when to leave well enough alone. Adjudicated insurrectionist is dead. You cannot use it. But rebellion is right there in your face, and it's an easier, quicker route. But everybody hangs on the adjudicated insurrectionist. Trump has indicated he's going to destroy the country. He's got Musk. He's senile. This argues exactly what the Hill article argues. Congress is charged with deciding if a constitutionally ineligible candidate may be excused of their transgressions to be certified and sworn in. To do nothing leaves the constitutionally ineligible candidate's status intact to be an illegitimate president if the Chief Justice swears him in. This is the same thing Evan Bernick said in the Jessica Denson Lights On interview, and you can look it up. You can go look her up. She's not an attorney either. She's clueless. So the argument is to the court that Congress needs to do their job and support and defend the Constitution. Okay? And, one would think Mr. Raskin should know better. Peaceful transfer of power is not a constitutional factor, while Section 3 of the 14th Amendment is. There is a link to the article from Political. But sadly, but quite expectedly, the article is wrong. Understanding of voting to certify or not of Trump's votes. Only one person in the article makes the point. Gerald Maglioka of Indiana University makes the point Trump probably taking office without determination that he's eligible to hold office. There's no determination to be made. It is made. What must be done is to remove the disability, or Trump's votes cannot be counted. So it has self-executed on him. This is what people don't understand. He should be disqualified. He's already constitutionally ineligible. He is technically already disqualified if Congress doesn't vote to remove that disability of disqualification. That's the point. They do nothing, he remains disqualified. It's automatic self-executing law. People don't understand. There's no option here. It's not like, we want to pick and choose. No. His conduct did it for him. There is no charge, no indictment, no court, no trial. Nothing is needed. And the Supreme Court said that. Yet, the article uses language like, even those who believe Trump is constitutionally ineligible, and I will vote to certify if Trump wins. And the article was written on October 31st. Both contentions are incorrect. Procedure according to the Constitution is the ECRA is to call for and address objections first, then, if none are cast or valid, to read and count the votes. Here, this year as never before, a constitutionally ineligible candidate has required electoral votes to be certified the winner. That is what is known as not regularly given in the Hill article. This is not regularly given. He's constitutionally ineligible. What he did on January 6th in a public way, 2021, cooked his goose. I mean, you can keep going on like nothing happened, but the issue was the state of Colorado could not keep him off the ballot. The state of Colorado could not determine he was an insurrectionist, not judicially in a court of law. And they should have never tried. All they had to do was declare his rebellion. That was the mandamus route that the state of Colorado law was expecting anyway. He tried to stay in power past 4 years. He had a fake elector scheme. There's a court order from Judge David O'Connor Carter in California. It says, well, this looks like a coup in search of a legal theory. That's literally what the order said. So there are 2 federal courts that have opined on the issue. So Mr. Popok is wrong. Mr. Popok is wrong about so much stuff. It's like every other thing out of his mouth is wrong or a stumblefuck. You know, he says something wrong. Oh, I mean, excuse me, Section 3, Article 3, he's what is called a spent attorney. He's done. And he may never have had it in the first place. But him and Ben Meidas are both spent attorneys. They're done. Their brain can't work in one direction long enough to stay coherent. And, you know, the really sad part is that the way YouTube works is if you can just fool enough people to keep subscribing and keep liking your videos and keep commenting on them, the algorithm will move you to the top and you'll get more views and more likes, and you can be wrong as rain and it won't matter. So, the vote is required by law, and this would be no different than if 1/5 of both houses agree. Then an otherwise constitutionally ineligible candidate as to age, natural born status. The Hill article says the same thing. Now, this arrived at the court the same day that our Hill article was posted. So there's no collusion. It's that just 2 people that see the law the same way. So, you know, if, as the article says, Democrats are more frightened and focus on a peaceful transfer of power to destroy the country, then they need to go on record first as the first salvo to destroy the Constitution and the American government. Go vote for Trump. Vote to relieve his disability. Or shut up and do your job and bar him from office by not voting to relieve the disability. It's not a question, and it's not that the Republicans can control anything. They don't control a 2/3 majority. So they can't stop this from happening unless the Democrats help them. And right now, I think all those people in Congress just want that $175,000 a year salary. And they don't give a happy hoot about the country. And if they don't take that vote, the count of any votes for Mr. Trump are invalid. It doesn't mean Justice Roberts won't swear him in. It may mean that Justice Roberts may step up there and say, I'm sorry, Mr. Trump, I cannot swear you in. And then he could summon Kamala Harris to the podium and swear her in. He wouldn't need, Congress, because they've done their duty to ignore the constitutional ineligibility which transformed into a disqualification. That's what would happen, that the Supreme Court would say. They could keep the embarrassment to a minimum. So, here's a statement on injunctive relief, and then a conclusion. And I'm going to stop there because this is the only thing I'm aware of that's been done that actually has been moved to court to ask that the court do something. And what is being asked is that the court declare that the 1/5 majority of both houses on an objection on Section 3 of the 14th Amendment is unconstitutional. You can't have a vote to declare whether or not the Constitution should be enforced. It just simply is. You know, one objection is all it takes to raise the point of order, and then a vote should be called. And all it needs to be is someone needs to identify that what he did on January 6th was a violation of Article 2, Section 1, Clause 1. Neil Katyal said it. Judge Luddick said it. There's a bunch of people have said it. Judge Luddick is in an interview with the Washington Post where he says that had Jack Smith charged 18 U.S.C. 2383, he would have run into a freedom of speech issue. And that's true. He ran into it anyway. But that's not what, there was no insurrection. He incited an insurrection, but the insurrection didn't happen all the way through. And it doesn't matter because in Colorado, that was the wrong court. That court had no jurisdiction to decide the insurrection status of a federal candidate. And this is what people can't get through their head. They keep talking about he's adjudicated insurrection. He's adjudicated. There was a trial. Wasted time. All wasted time. Now, here, let's start with Mr. Popok and his ridiculousness. And then Brian Tyler Cohen with Glenn Kirshner again, and his ridiculousness. Adjudicated insurrectionist with Kirshner. And then Anthony Davis with his toned down recitation of the Hill article without giving any credit there too. And, you know, he sums it up too in a political sense. Nobody has the appetite to do this. No, that's not the point. The point is they have a legal duty to do it. If they don't do it, this is what happens. You install an illegitimate president. Then what do? Well, what you do is quo warranto. But, you know, given what Democrats have done so far, none of this will happen. And if this doesn't get before a judge, and by the way, by the federal rules, because this is a related case to U.S. v. Trump before Judge Chutkan, this case, although it's new, should go to her by the federal rules. And we'll see if that happens. But this is December 31st, 2024. The courts are closed. The court responded with a request for one more document. And they're closed now. So they won't be open again until Thursday, January 2nd. So then the 2nd and the 3rd, and even though this is marked as an urgent matter, that's all the time that Judge Chutkan would have if it gets to her. to read and make a decision. Mr. Raskin and the rest of the members of Congress have been asked to be ordered to call the vote. That's the two things that this asks. That the 1/5 requirement of both houses for the objection to be valid is unconstitutional, and that Congress be ordered to call the vote. Under the Constitution, as it plainly states, as the D.C. Circuit Court of Appeals has plainly stated, that Mr. Trump was in rebellion to Article 2, Section 1, Clause 1. And the judge has the power to do that. It seems kind of funny. She has the power to order Congress to call the vote because it's Trump. You'll notice that Popok, Brian Tyler Cohen, no law degree, no attorney. Jessica Denson, no law degree, no attorney. They try and have on people who explain it. Now, Evan Bernick, he explained it as properly as possible. But Glenn Kirshner, he's just got it wrong in a bold way because he's stuck on adjudicated insurrectionists. He says a few things that are true, but he's stuck on adjudicated insurrectionists. And it doesn't matter. When you're stuck on the wrong thing, everything out of your mouth is worthless. And Popok, he doesn't have anybody on. He doesn't put up any proofs. He doesn't show anything that he's talking about. And what can I say? So let's start with him. Okay, this is the Anthony Davis article. Can Congress block Trump? Posted December 31st. That would be today. There's the URL up top.
The U.S. Constitution bars anyone who is engaged in insurrection from holding office, as outlined in Section 3 of...
Okay. So he starts out with insurrection. Okay, if he was an attorney, he would know the insurrection angle is dead. But what he's doing here is he's basically reciting the Hill article from December 26th. He doesn't give credit, but it's almost point for point what the article says. And insurrection doesn't fly. Not insurrection. Rebellion flies. And rebellion is a different argument, only slightly, because it requires Article 2, Section 1, Clause 1 at minimum. There's about 20 other things that Trump has done in violation that feed to Section 3 of the 14th Amendment violation. But it only takes one. And that one alone would do it. He's not an attorney. He's from Britain. He thinks he understands American law. He's over here reporting on political scenarios. And he's not unlikable. He's just not liked.
The 14th Amendment, this provision states, no person shall hold any office, civil or military, under the United States or any state.
You go look for it yourself. Let's go to the end.
the power of rich white men in America who, time and time again, appear to operate above the law, despite their crimes being widely documented and supported with evidence. It seems there is no
I don't see what that has to do with it. The issue is very simple. Congress needs to enforce the Constitution. The Constitution stops Trump. If the Democrats would just say, you're already disqualified under Section 3 of the 14th Amendment, you're constitutionally ineligible, and we're not going to excuse it. And without 145 votes and 34 senators saying it's okay, you remain disqualified. Now, they could scream, Supreme Court, Supreme Court, Supreme Court. Supreme Court would say, we already ruled on this. Your conduct put you here. If Congress will not excuse it, then you are disqualified. I believe they'd be that simple. Because Trump's already making a mess. But listen to this.
Or willingness by anybody to really go forward with this notion of disqualifying Donald Trump. Arguably, it should have been done a day or two after the insurrection on January 6th, with his entire scheme being exposed, including the fake electors scheme, which was planned months in advance. There is little doubt in anybody's mind as to what...
And there, he's right. Jack Smith and Merrick Garland screwed this pooch. Because, you know, there was a referral to the Justice Department on incitement to insurrection. But since he'd already left office, there was only one thing to do: bar him from taking office again. And it didn't require a trial. It didn't require, anything to convict him of anything, because that wasn't going to do the job. What needed to be done was to simply enforce Section 3 of the 14th Amendment. Judge Chutkan could have just as easily written an order determining that he was disqualified. At that point, his appeal would have been to Congress to get that 2/3 majority vote to remove it. If he couldn't overcome that hurdle, he would have never been on the ballot, because the proper federal court would have ruled properly, summarily, in mandamus on his conduct, and that would have been it. But you notice that nobody speaks that way, because they don't know what they're talking about.
Went on, but the mechanisms in place to deal with it, considering that Donald Trump has presented himself as a populist as well as a victim of a shooting and political witch hunts, makes holding him to account all the more impossible. I doubt any individual, let alone political movement, will have the strength to stand up to this rise of authoritarianism that has taken over the Republican Party. I'm Anthony Davis. You can find me on the 5 Minute News YouTube.
And this is where people mix law with politics. It's pretty simple. You did the deed, you're disqualified. Don't care that you were shot. Don't care that you're, witch hunt. None of that matters. And people should not have tolerated it. And Jack Smith made it worse by dragging it out with that ridiculous indictment under 371, 1512, and 241. None of them would bar him from taking office. The proper indictment would have been 18 U.S.C. 2383, 2384, 1918, and 2331 sub 5, domestic terrorism, and 18 U.S.C. 241, in a continuing sense of terrorism, which fits under the Haitians eating the dog and cats thing. We'll see if the court rapidly looks at the issue and acts in time for January 6th. This, I think, is just going to be a posterity video, and it's just another way of saying it's been said. But Popok and Marcellus, Davis, Cohen, Brian Tyler Cohen, and even Michael Cohen. None of these people are doing America any justice, whether they're attorneys or not. Marcellus is an attorney, and Michael Popok is an attorney. But you know, every attorney is not a constitutional lawyer. And even a constitutional lawyer will miss the clues. I get the feeling Mr. Raskin is missing them too. He talks about adjudicated insurrectionist. He talks about, losing the election by 3 million votes. Kamala Harris by 3 million votes, popular vote. When the reality is Kamala Harris lost by 230,000 votes. 230,000. That's the 229,790 something votes across 3 states of Michigan, Wisconsin, and Pennsylvania. The Democrats ran the wrong candidate. You would think they would learn from Hillary in 2016. This was not the time to play let's try another woman. The glass ceiling broke on us, on everyone. Kamala Harris was too nice, too sweet, too small, biracial, and a particularly hated biracial issue for whatever reason. She was Jamaican, Indian, Caucasian. There's a Indian Caucasian. That's what it says on her birth certificate. And she smiled and laughed too much. She dodged too many questions. She gave long spaghetti brain answers. She was just the wrong candidate. I like her. She's likable. But she's not the president. She's not presidential material. She could be the president yet. But this is why no one voted for her. People just stayed home. They didn't turn out. They weren't going to be motivated to vote for her. She said the same things over and over and over again at every one of her rallies. And she kept dodging the meaningful social media shows, like Joe Rogan and a few others. She dodged them. Well, there's an old joke about a man hires a prostitute, and the prostitute can tell immediately whether her John is a Republican or a Democrat. And the way she tells is that the Republican comes in, gets right down to business, doesn't say much. The Democrat, they want to sit down and talk about it, talk about it, talk about it, talk about it. Okay, here's Brian Tyler Cohen with Glenn Kirshner. Again, with the adjudicated insurrectionists. They are attempting to analyze the Hill article by the 2 ex-law clerks of Justice Potter Stewart. The bottom line of the article is simple. Once the conduct is done, and then it is publicly recognized, the bar to office attaches. That's what the article is saying, plain and simple. Once the conduct is done, the bar to office attaches after the conduct is recognized and proven in any public record. And these authors attempt to use, a couple of public records, being the January 6th committee, being the original impeachment, second impeachment, articles of impeachment, incitement to insurrection, and being the Colorado case where, he was represented. But none of that matters that he's represented. None of that matters, that it was an impeachment. What matters is the conduct was recognized and publicly recorded. The bar to office attaches. That's what the Supreme Court has said. I don't know how many other ways you could say this, but people are trying to make it so much more complicated than it is. Maybe that's why Ragaswamy and Elon Musk say Americans are stupid, that they're retards. Maybe that's why they're saying that, because they're trying to make a whole lot more out of it than it is. And I have a feeling that Mr. Trump really knows it's going to be a close shave to get past January 6th, and even if he does, he won't be the actual legitimate president. He doesn't care. He ignores law. But there's the URL at the top. This is the title. And it was posted December 29th. Okay, here's Brian Tyler Cohen. No sharkskin suit today. He's got Glenn Kirshner. He plays the idiot and Kirshner answers the question. So, here we go. Keep up. He's fast talking.
You're watching The Legal Breakdown. Glenn, there's an article in The Hill right now that's capturing a lot of attention as we inch closer and closer to Trump taking office. And the headline of this article is Congress has the power to block Trump from taking office, but lawmakers must act now. So I want to talk about two things here. I want to talk about both the argument presented in this article and, of course, the likelihood of it happening. But let's start with the former first. So can you lay out what the authors of this article are trying to say?
Yeah, Brian, I'm not sure that the United States Supreme Court would agree with that headline or with the conclusion of the authors of this article. They're actually two.
There he is. Already, the Supreme Court would agree. I think the Supreme Court would agree, because in the ruling, the Trump v. Anderson ruling, the Supreme Court speaks to Congress acting to post-election to prevent the insurrectionist president-elect from taking office. It is at page 8, referring to footnote 2. There is pretty much all throughout page 7 and page 8 the meat of the order. I don't think Kirshner read it. It also says again, Section 3, unlike other parts of the 14th Amendment, activates on conduct and nothing more. The bar to office activates on conduct and nothing more. That's what was shown at the beginning of the video. So already Kirshner has no credibility.
Lawyers, both of whom are former clerks for a Supreme Court justice, but it's actually a pretty compelling argument. And in essence, here's what they say. They say that Donald Trump is an adjudicated insurrectionist. Indeed, 3 times over, they...
This is where they keep going wrong. But in this particular case, these two authors are making the point that once you've done the conduct, that the bar to office attaches. But Kirshner can't read it that way. You go read the Hill article, and the link to it is in the previous video. And I may have that clip that I might be able to put into this video. I don't know how much longer it would make this video. But they're saying insurrectionist or rebellion, the conduct has already attached to Trump.
Urged that he has been found to have engaged in insurrection, and frankly, I think they're right on that score. First of all, we all know that a Colorado court, after a trial on the merits, a trial at which Donald Trump was represented.
His argument has no water. His argument holds no water. His argument is full of holes. Forget the Colorado court. Forget the insurrection. Forget the Colorado court. The conduct and the conduct alone has attached the bar to office. The Supreme Court said so. If you read the order, it says right there. Just like in the beginning of this video, it says exactly that. There is no other way to interpret that. It activates on that conduct. The bar to office activates on that conduct. And nothing more. Meaning, you're constitutionally ineligible. And nothing more is required. No charge, no court, no ruling, no indictment, nothing. Nothing. You're doing more steps than are required.
That Colorado court found, as a matter of fact and law, Donald Trump engaged in insurrection. The Colorado Supreme Court
I'm not going to listen to you.
Rule qualified by operation of Section 3 of the 14th Amendment, congressional legislation or no congressional legislation. That is the argument that they lay out, and I think it is, as I say, a compelling argument, but I know we're going to move on, Brian, and I want to give you a chance to pose the next question as to whether we think it's a winning argument.
Correct. And so now we have the virtues of the argument that the authors made.
No such thing as a winning argument. It is over. That is what it is. It's not an argument. It is the law. The conduct activates the bar to office. The bar to office is the constitutional ineligibility. That is what the Supreme Court called it in the first paragraph of the Trump v. Anderson ruling on March 4th. And now Congress must remove it or not. And if they don't remove it, then he is disqualified. You can count his votes and they're null. The votes are null. It's just what it is. It's a sad reality that Congress hasn't got a clue what they're doing. It really is. But several scholars have been telling them this. And if it doesn't go right on January 6th, that's when everybody's going to come out of the woodwork and say, those votes, he's not certifiable. Then they're all going to come out after the fact and say, he was disqualified. And they didn't vote to remove the disqualification. And so now he's an illegitimate president. He can't be sworn in. And Kamala Harris has to be certified the winner. I'm not going to listen to Brian Tyler Cohen. He might as well be a Republican operative because he keeps trying to understand law with politics. MAGA Mike Johnson and the Republicans do not control a 2/3 majority of the House and Senate. They cannot stop this. The Democrats are the ones who would help Trump get into office. That's the long and the short of it. If the Democrats just stand up and say no, the Republicans cannot reach the 2/3 majority to relieve the disability Trump remains constitutionally ineligible, but now disqualified. I'm not going to listen to the rest of this because this is going to be BS. I don't think the URL was at the beginning, and I don't know how to get back to it.
Here, but then I want to come back into what I think practically speaking is going to happen. And
Forget practically speaking. If you were an attorney, you would not be saying practically speaking. You would be saying what is unlawfully about to occur. See, you got your. This is why people who don't have law degrees should not be in Congress, and they should not be doing legal broadcasts. Because you're talking crap.
I think you and I, and probably most people watching, can agree that what will happen is different than what should happen, but what will happen is there will...
I'm not going to listen to this.
Then the issue might be met. Both parties will be asked to brief and argue whether there has to be an act of Congress or whether Congress...
He's stuck on Trump v. Anderson. If you read it, if you read Trump v. Anderson, Congress is telling them to do this. Congress is literally telling, Supreme Court is literally telling Congress to do this. Make up your mind. Either vote him relieved or vote him in. If you vote him in without relieving him, he's illegitimate. And, you know, this is where ding-dongs need to learn to read. But this article is fairly clear on how it's supposed to work. This was posted the day after Christmas, 12/26 at 8 a.m. There's the authors, and it's The Hill. Now, I'm not going to talk about the beginning of this, but we're going to skip right to the part where it says that they're wrong. Some argue blah, blah, blah. This view lacks merit for 3 reasons. Okay. The first is the majority's suggestion that there must be new implementing federal legislation. Bunk. But there already exists legislation. It's in the D.C. Federal District Court. So let's just skip right to the meat. Crew brought the case in the wrong court. Okay? It may have been Colorado law, and that's fine. But when you're dealing with a federal question, you bring it in a federal court using state law, claiming a federal question as to why it's in federal court. In many places, it's called the Erie Doctrine. Federal procedure, state law. In this case, the state law was basically a mandamus law. But instead of doing that, what did they do? They had an insurrection trial. Okay, no, wrong thing. Ben Meiselas doesn't address any analysis of what happened in the case, and I'm pretty sure he doesn't understand it. Now, this Hill article has several links to things like what lawyers call dicta, and it'll take you to a definition or something like that. You can spend your time doing that if you want. I don't know where they get the holding that Section 3 is not self-executing. Maybe an alternate holding. The court didn't say that. The court said the opposite. the court said Section 3, unlike other parts of the 14th Amendment, is conduct-driven. It says that when you take a qualifying oath and you do something that violates that oath, the bar to office attaches, and nothing more. Okay, that's self-executing. The Supreme Court has defined it as self-executing. Now, it talks about an overreach is a power grab which Congress is not required to credit. I don't know what they're talking about. However, it's not an overreach. The difference is you're talking about state court power versus congressional power. The Congress has the power to enforce Section 3. It may do that by enacting legislation and handing it off to something else, which it did do. And mysteriously, the Supreme Court acted like they didn't know about this. It's in the Binkley brief, Binkley. It specifically talks about how Congress has already granted exclusive jurisdiction to the D.C. District Federal Court. That is the court where this Colorado case needed to have been filed if you're going after a federal candidate. It could have been filed in quo warranto, but not necessarily. It could have been filed preemptively. The Binkley brief says it has to be filed after he wins the election. Well, that's not true either. But if you read that brief, it says that if he's sworn in and the Section 3 of the 14th Amendment vote is not taken, clearing him of the disability, then he is an illegitimate president. He can be removed by quo warranto. Read the brief. It was previous to this. Then it goes, second, the Electoral College votes are a matter uniquely assigned to Congress. See, so when Congress does this, guess what? The Supreme Court will have no jurisdiction. Whether Congress has the chutzpah or the balls to do it, I don't know. I don't think so. Then third, specific legislation is designed for this situation already exists. The Electoral Count Act and the ECRA of 2022. The Electoral Count Reform Act, which is the ECRA of 2022. And it tells how you use it to file an objection. Okay, you can make an objection based on Section 3 of the 14th Amendment. The problem is the ECRA of 2022 requires 1/5 of the members of both houses for the objection to be valid. That's unconstitutional. A court may weigh in on that sooner than you think. The Act specifies 2 grounds for objection, and it talks about them here. One is where the electors were not regularly given, and a vote for a candidate disqualified by the Constitution is plainly in accordance with the normal words, not regularly given. So, if you're not qualified in terms of what the Constitution states, which is age, citizenship from birth, and 14 years residency, then you're disqualified by the Constitution. But right now, Trump is constitutionally ineligible because he has violated Section 3 of the 14th Amendment. Then it goes on to make an objection under the Count Act requires a petition, and it's signed by 20%, which is 1/5 of each house. That's what I'm maintaining is unconstitutional. Now, you can go read this article yourself, and you should. Because listening to people like Ben Meidas, who he just gets this all wrong. Now he's talking about MAGA Mike Johnson won't cooperate. Ben Meidas can't count. 2/3 the vote of both houses are required to overcome the Section 3 of the 14th Amendment violation. The Republicans do not control 2/3 of the votes of both houses. So the Democrats can take a stand with, as I've said before, 145 reps and 34 senators will keep the 2/3 majority from ever being reached. Now, this is the end of the article. It identifies the authors, Evan Davis and David Schultz, and these are constitutional scholars. They both clerked for someone in the law. One was a chief, as it says, of the Columbia Law Review, and the other was editor-in-chief of the Yale Law Journal, and both clerked for Justice Potter Stewart. So, among the most measured reports from YouTube content creators, and especially through the Meidas Touch network, is the Anthony Davis report, where he simply reads the Hill article but doesn't credit it to the Hill authors. And he speaks to a petition needed in Congress for the objection. That's the act that Congress must do now to stop Trump from being certified the winner. There's no vote to certify him. It's just a ministerial process which has now been clarified in the ECRA of 2022. They call for objections. If no objections are brought forward according to the new rule, which is 1/5 of the members of both houses agreeing on the same objection, or the same document, and all of them signing it and presenting it in writing, then no valid objection is found, and they proceed to count the votes. There is no vote to certify Trump. It just is. It is a ministerial act by the sitting president of the joint session, which would be Kamala Harris. It's not clear if she could register an objection under the Constitution, but I don't see why she could not, because that's a ministerial act also. She could call for the point of order. It would be unusual. It would be ballsy. So here's the conclusion, and there's no saying if the court will get this petition and act on it in time for the joint session. This is not the petition Congress needs. This is a petition to the court for the court to order Congress to take up the Section 3 of the 14th Amendment objections that have been sent to them. And there's 20. But the main one being the Section 3 of the 14th Amendment violation, which the D.C. Circuit Court of Appeals declared as the violation of Article 2, Section 1, Clause 1 of the Constitution. And so the conclusion is, to the court, peaceful transfer of power, which all the Democrats are crying, we want a peaceful transfer of power. If you go back and read the Political article, this is their fear, this is their justification of their fear. Because make no mistake about it, they're all scared crapless that Trump supporters are going to come out of the weeds and attack them, shoot them, kill them. And it's very possible they may. That doesn't negate their job. So peaceful transfer of power is not in the Constitution, but the command of Section 3 of the 14th Amendment is. Mr. Raskin went on Chris Hayes, and Chris Hayes bluntly asked him, what are you guys going to do? What are you doing? What are you going to do? And Raskin responds, what can we do? But, January 6, 2025 is the time to object and do what his oath and office requires. There's the link to that video. It's not going to work. This link won't work directly because this is an image on YouTube. You would have to copy this link, but the video starts after the V equals, and that's the number. And you can stop at the ampersand T equals, because ampersand T equals will jump you right to 900 seconds inside the video. And the argument being made to the court is many other legal scholars understand it this way. Now, this actually arrived at the court the very same day the Hill article was posted. And it argues right here, many other legal scholars understand it this way, including Lawrence Tribe, Neil Katyal, and the interview with Judge Ludwig in the same video. And it jumps there to T equals 1980 seconds, where Glenn Kirshner begins to speak. It tells the court this video is a compendium of public record, highly relevant. Then it refers to another video where Lawrence Tribe explains why the act of any disqualifying activity, the Section 3 bar to office attaches upon proof of same by any reliable public record. There is that for the conduct. That's what the Supreme Court is telling you. Conduct and nothing more. Arguing to the court, no court nor charge is required. This is why Lawrence Tribe describes Section 3 of the 14th Amendment was drafted the way it was, and why the courts were designed out of the section. And there's a reference to that video. Again, after the V equals and the ampersand T equals 3240S, jumps to 3240 seconds into that video. I believe that's a Pod Save America interview of Lawrence Tribe. And then you tell the court, upon the final draft of this petition, former federal prosecutor Glenn Kirshner discusses with Brian Tyler Cohen the Section 3 issue, in essence stating what this petition argues, but from the perspective of adjudicated insurrectionist of Mr. Trump. The insurrection route requires an adjudicated outcome, while the rebellion to the Constitution of the United States, congressional laws, is purely conduct-driven by the violation of a law or a duty. That is what the Supreme Court is saying. Once again, conduct-driven, bar attaches by the conduct only and nothing more. Meaning no charge, no termination by a court, no ruling. And why these people are so confused is because in their mind they think already that this is what the words say, and it's not what the words say. But they're angry, and so they see something different. Mr. Kirshner thus limits his legal analysis to the insurrectionist route. But both end at the conclusion this petition does. He states a court may need to direct Congress. And then there's another link to the full video. And you know, this is where Mr. Cohen illustrates why non-lawyers and people with no legal education should not be making legal-oriented educational podcasts. Heck, it illustrates why with Popok and Meidas, you know, they're unqualified too. There's another from Jessica Denson interviewing Evan Bernick of Northern Illinois University. There's a link to that video. You'll have to write these down. I'll leave them up there for a while. And then it speaks to how one attorney is confused. He somehow reads that Trump v. Anderson ruling requires legislation for the Section 3 to be used again. However, he's uninformed that is only one true issue for a state to do so against a federal candidate. That's what Trump v. Anderson is about. It's about state power only to use Section 3 against a federal candidate. That's all it says. That's all that ruling is about. It's very limited to that. There's no legislation required for any other use of Section 3. Now, the court does not make clear that D.C. Code 163501 is there. No, nor Quo Warranto is there. And the Binkley brief does make that clear, which is where the Supreme Court got their whole idea, it appears. The error of Colorado was to have an insurrection trial and try to use that to make Trump constitutionally ineligible at the hand of the state and bar Trump from the ballot. Many people and attorneys, including congressional members, misunderstand this with their beliefs. A link to another video. Now, you know, this is a popular thing today. The public record is YouTube. It usually is permanent. YouTube creators can take it down. MSNBC normally will never take theirs down. Most of them won't take them down. And YouTube won't throw them off unless they throw the entire creator off the channel. But it's as good a public record as needed. Anybody can go download these videos. There's a program called TubeMate that will let you download the video and keep it. Then it makes the point at paragraph 40 here that Trump v. Anderson was about the states enforcing Section 3 upon the aspect of insurrection, not rebellion, to the Constitution and congressional laws, which is a straightforward breach of duty or law, shown by public record of disqualifying activity in rebellion, which Congress may enforce directly through private or existing legislation, and this is the case of the ECRA of 2022, as an objection levied. Furthermore, D.C. Code 163501 is also existing legislation granted this court, and see the Binkley brief. And there is a link to the brief. Again, you can go straight to the Supreme Court and read it, or you can take the time to write down that long URL. DC Code 163501 is where the remnants of the Enforcement Act of 1870 as quo warranto landed by the hand of Congress in this court exclusively to enforce Section 3 of the 14th Amendment. Thus, this is the right place under proper legislation of the ECRA to seek that Congress do its duty and enforce Section 3 of the 14th Amendment as to an automatically constitutionally ineligible candidate that by his own conduct has found him in need of relief of the disability he created upon himself in rebellion to the Constitution and congressional laws. That's Trump's folly. This is not about a state through the state courts and private actions seeking to enforce Section 3, as was with Trump v. Anderson. The Supreme Court got it right in a clumsy way, not making clear that only a federal court or Congress may rule a constitutional ineligible candidate status into a disqualifying activity, disqualified state. That means either they vote to remove the disability or they leave it stand. Then it becomes a disqualified state. The conduct is disqualifying activity. And there is a congressional research primer that identifies disqualifying activity. And I believe it's like LM 1059.pdf. I don't know. If you search Section 3 of the 14th Amendment, Congressional Research Service, it should pop up. We are at this point where Congress must call for the vote based on the objections it has been sent on Trump's conduct and public record. Thus, constitutionally speaking, it only requires one party, congressional or public, to lodge a Section 3 of the 14th Amendment objection at electoral count time and the provisions of the ECRA of 2022 requiring 1/5 of both houses for a valid objection is itself unconstitutional as being a hamstring to Section 3 of the 14th Amendment, meaning it gets in the way. You can't require 1/5 of the members of both houses, 20% of the members of both houses to vote to enforce Section 3 of the 14th Amendment. That's ridiculous. And, paragraph 45 says that. Here, if the required vote is not called for, January 6, 2025, a constitutionally ineligible candidate will have votes counted in violation of the ECRA of 2022, certifying a constitutional ineligible candidate. And then the prayer for relief says, adopt and respect the ruling of the Supreme Court in Trump v. Anderson. For the court to respect and adopt the public record by the judicial determination of the D.C. Circuit. Now, it doesn't take a genius to figure out that this has all been done. It's in the law. Now, let's go see what Congress has been sent. This is Exhibit A, which is the facts sent to Congress. Who will have the patriotic courage to call a point of order? This was sent by gang fax to over 30 members of Congress with good sins. So there's a record that it was sent, and there's a record that they received it. Will there be a support and defense of the Constitution? And we're asking them. And it says you can download a searchable hyperlink copy at satpack.com. So there's an objection they've been sent. Then it talks about the same political article where you're all afraid. It talks about Trump v. Anderson. that they do not have jurisdiction. That's what the Supreme Court said. Congress has jurisdiction. Congress has to do that. And they're all sitting up there going, well, the Supreme Court kicked it to us. No, they didn't kick it to you. That is what the Constitution says. Congress is cowering to Trump supporters. Make no mistake. There's a duty to file this or something very much like it. And it goes on. Sounds unfair? No, because Trump and the Republicans had millions of people purged. There's a lot of voting shenanigans that went on. There's a couple of links. Again, you'd have to write these down because this is an image, not a linkable video. Congress, the Republicans will scream Supreme Court, but the Supreme Court's already ruled. If you read the order, it says states have no power to find him constitutionally ineligible and disqualify him from the ballot. But Congress does. And Congress does this, as the Hill article says, it's in the exclusive jurisdiction of Congress. Here is the beginning, first page of the objection. This is the petition that Anthony Davis speaks of. There is the link that you could use to download the full objection. Ask it any member of Congress. Here is another page, second page. It argues exactly what the Hill article is arguing. So the question is, did somebody get hold of this first and then write the Hill article? Or is the Hill article and this just happen to be in sync? Now, let's just pop up. That's Exhibit A. And then Exhibit B is the actual political article itself. And you could pop that up yourself also. I don't know what else to say. These YouTube people are constantly hollering, resist, do something, let's get together. And they're talking into the ether. Nobody can do anything. They don't read their comments. Often there's millions of comments. They don't read them. They don't have a solution. They're not even asking for people to put forward solutions. And when people do put forward a solution, well, they ignore it or they delete it from their comments. Trust me, they delete it. They don't want to be known as idiots. And here at the very bottom of this second page is the reference to the Trump v. Anderson ruling, where the Supreme Court writes this. This case, this is the meat of the ruling. This case raises the question. We conclude that states may disqualify persons holding or attempting to hold office, but states have no power. This is about the states, not about Congress. Then there's a reference to page 8, footnote 2. If you want the truth, I encourage you to download this and read this objection. Then contact your congressman. You can look up their fax number, if they have one, at Congress Web by just typing in the word in Google, Congress Web, all one word, and the space, and then the representative's name. And it's going to bring up normally a link to their contact information. Many of them that have faxes, you'll find the fax number there. Contact them and ask them, what are you doing? What's going on? Now, this may end up being basically a video for posterity, just to show somebody did actually do something. Whether it's going to work or not, I don't know. But this is the petition that Anthony Davis talks about. This is the petition that Michael Popok talks about, where he would get together his 20 people, to sign a petition, la la la. And all of them have been sent this. Many, many people, including Meidas Touch, have been sent this directly as a PDF file, complete. Anthony Davis, all of them have been sent this. Now, either they don't read their mail, or they ignore it because they don't believe this is possible. And you know what? Until the Hill article came out, this was getting no traction at all. There is the joint objection. There is the section right there at the top. 3 U.S.C. 15D2 B double I, whatever it is. LLII. That's the objection section that you filed a petition under. Anthony Davis speaks to this. This is the petition that he's talking about. So I encourage you to go here and download it, and I'll see if I can bring it up. Here's the sadpack.com site. Let's see if we can find the petition link. I mean, if you really want to know what's going on, go here and read this. There it is. It's here. This objection on January 6, 2025. And this is it. This is the live and public version. Now, this is case sensitive, so if you don't get the link completely right, it won't work. If you have small case, like small case objection, joint session, it won't work. It has to be exactly that link above. And I'm not clear if these links will work, but this is a downloadable file. And this is the full file. It's 20-something pages. Well, I think 30 pages. I don't know. Let's go to the end and see what it is. But this has 20 objections. And it chronicles Trump's conduct, and in part, J.D. Vance's conduct while they were on the trail. With the Haitian cats and dogs. That's a violation of Section 3 also, because it's a violation of 18 U.S.C. 241 to threaten those people, to make those claims. This goes on. This is actually doing something. Whereas Popok, Mycelis, they just get up there and they start talking. And they don't even know what they're talking about. So it's 19 pages. This is what they would sign. They would need to expand this to reach 34 senators signing it and 145 members signing it. That would end it. There would be no vote then. because the objection of those people would preclude them from reaching a 2/3 majority vote to relieve the disability, and all of these objections would then stand. I think it's a minimum that it said in the facts above that 81 or something made it valid. Then they would have to vote. But if these 34 senators sign it and 145 reps sign this, then there can be no vote because they can never be 2/3 majority. So there's the link. This is the actual word. This isn't a lot of guessing where Popok was making all this postulating. Is what about this and what about that and what happens then and why are you sitting up there telling people you don't know what you're talking about? And you're telling the people, postulate this and postulate that. That's absolutely ludicrous. That's ridiculous. He's supposed to be an attorney. He's supposed to have the answers. Don't get up on a YouTube video and talk about it unless you have the answers. You don't have the answers, don't make a video at all. Don't get out there and just throw it into the ether. What about this and what about that? And then say other things that are absolutely wrong. Congress had access to this. And the public has access to this. And this, or something very much like it, is an objection that would be needed. And then they would all, go back to their little chambers, respective houses, respective houses, and they need to read this, and they need to watch these videos, and they need to then decide on each one of these objections, assuming enough people sign this objection to make it valid. Then they would vote on each objection, and a 2/3 majority vote in each house would be needed to relieve the disability, because the disability of each one of these objections, and they're numbered in here somewhere, there's objection 16. There's objection 15, and it's so on and so on. 14. You can't. This is what needed to be done, and the bottom line is this: the Democrats are cowards. They're scared. They're not going to do this because they don't have the chutzpah, aka the balls, to stand up and tell the American people, you cannot vote for a crazy person to become the president. We don't have to allow it. Even if we're in the minority is the majority when a 2/3 vote is required to relieve the disability of automatic self-executing bar to office based on the conduct of the candidate. Where did the conduct come from? Throughout his entire campaign, he ran a campaign of lies and conduct. Lies and conduct unbecoming a president that violate the Constitution. It violates justice, domestic tranquility, and to form a more perfect union. That's what you need. That is the mindset you need to be the president. Okay, it's not about deporting people. It's not about causing strife. It's not about ripping people apart. It's not about trying to deport people of color. Really, enough with the craziness. That's not what the American president is supposed to be. And until we wake up and realize that we need to enforce the Constitution every day as to justice, domestic tranquility, and to form a more perfect union, these Republicans will continue with this ridiculousness. Justice means you don't lie. You don't lie. Domestic tranquility means you do things that hurt as little people as possible. And to form a more perfect union, well, that means you're not a racist. You don't go out there letting people talk in racial ways. And you certainly don't grift and steal money from foreign governments in violation of the law, like Objection 11 here talks about. I encourage you to go download this and read it. And then call your, it may be too late. This may be a posthumous video, but it's been said. It's been said all the time. This has been going on for months. And has anybody on the YouTube media or the general media or the general media that's on YouTube like MSNBC, has anybody picked this up and reported on it? No. Many of them have been sent it, however. Meidas Touch, I know, has been sent it. There are many people that have been sent this who proof exists that they got it. Neil Katyal, Orange Tribe. There's a host of others. Melissa Murray. A number of these people actually got this. They got the link to this. So it wasn't until these two guys actually published that article on the Hill that anybody started talking about it again. So I'm not going to go on and on anymore. But it's all right here. Okay, this is what it looks like when your past catches up to you. And this is the legacy of Trump. It's been nothing but non-stop 18 U.S.C. 241 violations in his campaign. And the Democrats are just like idiots. This is the law. Not all of them are attorneys, but they need to pull their heads out their butt. Here is the reference to 18 U.S.C. 241. This is in the objection. And I believe this is in reference to both Trump and Vance. Number 1. Objection number 1 defines 18 U.S.C. 241, says anybody who conspires to injure, oppress, threaten, or intimidate any person in any state. Oh my God, that's the whole Trump campaign. So, you can't say it hasn't been said. You can't say Congress didn't get this. If you ask me, people like Raskin and others who sit up on these shows and they make these appearances, and they know this exists, what's the saying? Throw the bums out. Because not only does the Constitution protect us, here is how it protects us, and the congressional Democrats are not doing their job. Hakeem Jeffries sitting up there talking about, we're going to do everything we can to make the transfer of power as peaceful as possible with as little drama. You know what? The Constitution doesn't say that. There may be drama. There may be strife. Enforcing the law is not always easy. People don't go willingly. You arrest someone, they're not going to just say, oh, the police are here, let me just go with them. No. They're going to resist. They're going to fight. Family members resist. They fight. Trump supporters want to resist and fight, but they need to be told they're in violation of the law. The law covers those Trump supporters also. 18 U.S.C. 2383 covers those Trump supporters. It'll put them in jail for up to 10 years. It'll strip their gun rights, their voting rights. It'll fine them a minimum of $1,000. You want to keep supporting Trump? Somebody just needs to enforce it. Now, the end result of this would be Harris would be elevated to the president. Does she have the chutzpah? Does she have the balls to call out the Insurrection Act, which will give the military the power to help arrest these people, to help detain any social uprising? I don't know. She doesn't appear to me to have that chutzpah. But the other side is letting Trump and his craziness in there. So here's the not regularly given argument. The results in votes not regularly given, and thus not countable. It speaks to Section 3 of the 14th Amendment. And here's the link to the Congressional Research Service article, which is LSB 10569. So I may have misspoke earlier. But I'm going to stop here. We're going to end the video here. I'm sure it's gone on a lot longer. But unlike these guys who get up here, put their face in the camera, and start talking, this actually shows you the reality of how this should have been done, how the effort was to do it, and the end result is, if the court gets this in time, and Chutkan has been known to work over the weekends and actually sees fit to issue an order ordering Congress to take the vote in minimum on Article 2, Section 1, Clause 1, because the D.C. Circuit has already declared he violated that part in minimum of a Section 3 of the 14th Amendment violation, and also declares unconstitutional the requirement of the 1/5 need of members of both houses to register an objection under Section 3 of the 14th Amendment. If that's all the court is being asked to do, then democracy has a chance of being saved. That's what SADPAC.com is about. Saving American Democracy, PAC. Now, people have donated to these campaigns and millions of dollars from these rich people and oligarchs because they want Trump to loot the Treasury and give them tax breaks. I'm sorry, but this is the last word. A thriving, growing society needs more taxes, not less. It costs money to support a civilization like the United States. The tax rate back in the days of Kennedy, I think, was like 35%. They don't want to pay that kind of duty to have a country like America, the United States of America. But you know what? What we did with that money? We went to the moon. We invested in technology. We invested in education for people to become smart enough to work on rockets And Elon Musk and Ramaswamy are telling you, today people are too dumb to do that kind of work. And let it be told, even in 1969, trying to go to the moon, we only got there by the grace of God. That moon landing, that lunar module was out of fuel. Had he gone another 500 feet, it would not have been a landing. It would have been a crash. And the whole thing would be a lot different because they'd be dead. You know, the whole thing was not as successful as you think. And the type of people who were at that time working on the moonshot, with all the money that America had, in times of peace, today, Mr. Musk has to hire under the H-1B visa program. Musk has these, booster sections that return and are reusable. I mean, any child who watched any science fiction movies as they were growing up, as Mr. Musk's age, would see rockets landing, standing up like that. And any child would say, "Can you really do that?" And then, yeah. And so he hired the best people to do the programming and do the actual building of a rocket that could land vertically. Trump's amazed because Trump's an idiot. He doesn't understand how it's done. He thinks it's some kind of magic. It's pretty easy. The rockets do what is called gimbaling. They move the nozzle to keep the thing standing up and land. We didn't have that capability in 1969. And we don't have that capability today without putting the taxes back to where they should have been. Is there government waste? Yeah, the biggest part of the government waste is in the military. Where, we had so much military waste that all of those weapons we sent to Ukraine, they were scheduled to be destroyed anyway. They were old, but they were old enough to be good enough to kick Russia's butt. What is the Ukraine war doing for us? It's just growing our economy as we build new weapons. That's nothing to be proud of. It is just fact. The Biden administration did an absolute horrible job of messaging. They did not properly message anything that they did that is of benefit. And the whole Biden administration did an excellent job. Didn't message anything right. Didn't even say, we were going to destroy these weapons anyway. That's how many weapons we have that were going to be destroyed. They're going to be destroyed or retired. That's crazy. And that's stupid. So, I'm getting off my high horse now. There's the link to the Congressional Research report when you pull that up, search on disqualifying activity, and you'll find the reference to how Section 3 of the 14th Amendment works. It's nothing Popok says. It's nothing Meidas says. It's nothing Anthony Davis says. Anthony Davis is not an attorney. Popok and Meidas are supposed to be attorneys. Meidas is a sports attorney. That's what he teaches at LSC. Popok doesn't teach anywhere. I don't know what he does or what he once did. These people are unqualified to sit up here and act like news reporters and report to you their wrong views. That's what's been going on. They are the Pied Pipers of American democracy, it's sad that advertising dollar puts them on YouTube front and center. But that's what's going on. They're getting paid to spew nonsense. Marcellus is Mr. Tattletale. He follows everything Trump does. He reads all these posts and all this social media crap. Popok pretty much does the same thing. They've somewhat split. Every time there's a separate channel created, that's a new revenue stream. That's a new advertising channel. And then whoever created that channel gets the revenue. Popok and Marcellus were once together. They've split. Meidas Touch Network simply now has a website that lists all of its so-called creators. But everybody who has a channel has their own revenue stream. Whether they're qualified or not, this is the model that's misleading America. This is the misinformation. This is the Fox News of YouTube. These people who have the wrong information, don't know what they're talking about, yet they're spewing it anyway as though they're an oracle. It's a bit sickening. You've been told.